Hello friends, in session number 29 of the series on military law lectures, we would be covering dual jurisdiction. Now dual jurisdiction indicates duality, that is a matter involving criminal law, in our case pertaining to discipline where the military as well as the civil law both have jurisdiction. Now, these matters would be covered in this lecture. It is to be appreciated that a person who is subject to military law is also a citizen of the country, and therefore he is expected, duty bound, to abide by all laws of the land which are prevalent, which are enforceable in India. This subject matter for the lecture is mainly to be covered under the guidelines, the procedures, and policy that is enshrined in the regulations for the army, and the main fulcrum there is on regulations for the army, DSR para 418. Now, how is this concurrent jurisdiction or dual jurisdiction decided? If an offender is an army person, there could be situations like the place that where he has committed offences in military area or civil area. This would impact who would have the jurisdiction in that matter, whether the offence is a military offence included in the Army Act or it's a civil offence, may fall under the IPC or Prevention of Corruption Act or Official Secret Act, etc. The custody of the offender is with the army or with the civil authorities who have carried out investigation or probed there, whether the army authorities till then or the civil authorities, and whether the trial by army would be expedient or by a civil or CBI court. Now, all these aspects would have a bearing on the matter regarding concurrent jurisdiction, how is that to be resolved. There are certain provisions under the Army Act that should also be kept in mind. For example, Section 105, Clause 1 of the Army Act says that, and this I am giving the gist, I have not reproduced the complete section here. So therefore, whenever any person subject to this act, means Army Act, deserts, the commanding officer shall give written notice about this fact to the civil authorities who may be able to afford assistance for his capture. Now, who are these civil authorities? Most likely a person who has deserted his home station or his place of residence. The police authorities there should be informed, because in all likelihood he may revert back to his home, and then these authorities shall take suitable steps for the capture, apprehension of such a person, and once he is captured, they deliver the person to the military custody. They may send it to the unit concerned, or they may hand him over to the nearest military unit, which then takes responsibility to transport this person to his home unit. The other clause is Army Act Section 104, which says whenever any person subject to military law, if he is accused of having committed any offence under the military law, and then he is within the jurisdiction of a magistrate or police officer. Now, the magistrate or police officer, obviously, having come to know that a person has committed military offence, then they are duty bound to aid in the desertion, correct, not desertion, apprehension. They will take all efforts for apprehension of such a person and his delivery to military custody upon receipt of a written application to that effect signed by the commanding officer. Now, this in practice entails that either commanding officer at the instance when he comes to know about military offence informs the magistrate or police authorities, or the magistrate or police authorities get to know that he has committed an offense, and they get in touch with the commanding officer to seek his views whether he would need the offender to be handed over to them, and if the answer is in positive, then the magistrate or the police authority shall take suitable steps to hand over the delivery of such an offender to the military. Now that in nutshell is Army Act section 104. And then there is a law contained in 105 clause 2, which says that any police officer may arrest without warrant any person reasonably subject to the act and who's a deserter or traveling without authority. Now this is the authority, power given to a police officer. He need not wait for a warrant, and if he has a reasonable suspicion, apprehension that a person is either a deserter or he is traveling without authority, he has nothing to explain why he's in that train or in that bus or whatever means of transportation, and then he would produce the police officer such a person before the nearest magistrate, and he would be proceeded as enshrined in the law. I would also like to take your mind to the definition of civil offences and the law relating to that, where Army Act section 69 has laid down that any person subject to the military law at any place in or beyond India, mark the words even beyond India, because Indian troops may be serving overseas beyond India, if he commits a civil offense, then he shall be deemed to be guilty of an offense under military law. And if he is charged, he shall be liable to be tried by a court martial. Therefore, what it lays down is that if a person, whether in India or outside, commits a civil offense, then it shall be treated as if he has committed an offense under military law, section 69, and that would lead to his trial by court martial. And if he is punished, if he is found guilty, convicted, then he can be tried as if it is provided under military law provisions. Now, there are two clauses under this. If the offense is punishable with death or life imprisonment, then he shall be given any punishment. Whipping was there in the British days, it is no more applicable, assigned for that offense under that law, and such less punishment as is in this act mentioned. What is to be understood is that the punishment which he is liable to suffer is what is there if he has committed an offense under IPC, then the punishment which is provided for that offense under the IPC, and any less punishment which is prescribed under the Army Act, he can be awarded both the penalties. Now, with regard to the remaining cases which are not punishable with death or life imprisonment, then he shall be liable to suffer any punishment other than whipping assigned for that offense by law in India, or imprisonment for a term which may extend to 7 years. So this, you would see that A and B clause contain both the contingencies, that is with regard to the offences punishable with death or life imprisonment and the other offences. Also, it is to be borne in mind that the next section, that is 70, says that a person subject to this act who commits an offense of murder or culpable homicide or rape in relation to a person who is not subject to military law. That means that the person who has been murdered or culpable homicide or subjected to rape is not subject to military law, then he shall not be deemed to be guilty of an offense under military law. He would be tried by the civil law. Therefore, these three offences have been kept outside the jurisdiction of a court martial, subject to three contingencies. Now, these contingencies are: if he commits an offense while on active service, On active service, he murders a person who is not subject to military law, in other words, a civilian, then the contingency of 70 will not be applicable. Or if he commits a murder outside India or at a frontier post. Now, these are the three provisos or exceptions where the general clause of section 70 will not be applicable and the jurisdiction will still be with military law. Now, the central government is empowered to make rules with regard to cases in which military persons shall be tried by a court to which this code applies or a court martial, and when any person is brought before a magistrate and charged with an offence for which he is liable to be tried either by a court to which this code applies or by a court martial, such magistrate shall in proper cases deliver him together with the statement of offence of which he is accused to the commanding officer. In short, what it lays down is a duty of a magistrate where an offender can be tried by court martial and he is with the magistrate, then a summary of the offence or the circumstances relating to that charge will be handed over together with the custody of that person by the magistrate to the commanding officer or the nearest commanding officer. And here it has been clarified that unit includes a regiment, corps, ship, detachment, group, battalion or company. So the definition of the term unit is sufficiently wide, and court martial also includes any tribunal. And now you got to bear in mind that there is an armed forces tribunal now in place. And every magistrate shall, on receiving a written application for this purpose by the commanding officer, use his utmost endeavor to apprehend and secure. So where help is sought by the commanding officer from a magistrate, the magistrate is law-bound to provide his assistance for in the apprehension and gaining security of a person accused of an offence. And lastly, a high court, where it is so desired, may direct any person who is detained in any jail within that state to be brought before a court martial for his trial. Now, obviously, the jail in that case would be expected to hand over the custody of an offender to the military authorities. Now, there are certain cases which can be handed over to the CBI, and this is enshrined in the regulations for the army. Why it is so? Because CBI is expected to have greater expertise to deal with cases, say, relating to corruption, where there is forgery of documents, cheating, a criminal breach of trust, records falsification, or possession of assets disproportionate to the known sources of income, or bribery, or other complicated cases which require expert police handling. So the military authorities, they invariably hand over such cases to the Central Bureau of Investigation, keeping in mind the provisions in the Defense Services regulations. On the other hand, there are certain cases which may commonly involve both the jurisdictions. To illustrate, motor accident. If a car accident or a truck accident has taken place, maybe in civil area or in military area where the victim is civilian, witnesses are civilian or military persons, or offences under Prevention of Corruption Act, Official Secret Act, or under the Indian Penal Code, domestic violence, marital discord, grant of maintenance, and assault and affray. Now, these cases, depending upon the factors which I had indicated earlier, like who's the offender, the occurrence, what are the witnesses like, whether the military is present in that area, would be decided whether the military should deal with that offender or it should be handed over to the civil authorities. It is to be appreciated that cases involving military personnel, property, or official transactions should preferably be tried only under military law, where the offense involves two or more military persons, or it is with regard to military property, or an official transaction. It better be tried by military law. Complaints against military missions or operations must be probed by military. Now, if something has happened while military was carrying out its maneuver or training or an operation, a mission should be handled by military, and offences by military personnel purely in civil areas or while on leave or involving their civil capacity should not be dealt by military. Now, these are the guidelines which over the years, decades, have found to be useful, and they are uh, usually followed and enforced. There are also certain cases which are allowed when a request is made to the civil authorities to handle. Means they are allowed, the civil authorities are allowed to handle the cases. For example, a matter involving property or title issue of any property, landed property, immovable property which is located in civil area or groups. There are family disputes, land matters in villages, or other type of offences where military does not have expertise to investigate. So it is natural that the military should not keep these matters with itself and allow it to be handled by the civil authorities. At the end, I would like to highlight that policy matters and policy guidelines issued by the Army headquarters from time to time regarding handling of these cases are based on actual expediency and service interest. They should be followed, and they are followed. And in any case where a larger number of witnesses are from the civil area, should not be handled by the military authorities. Thank you.